high on pot, in a borrowed
That's when
Lamborghini.
it was executed, yes.
Okay, all right. Now, then what is troubling is that this matter was before this court in September. But you go to Judge Michael Hathaway to get a, not by this court, not saying, hey Judge, we delivered this subpoena to Dean Valenti and he's not responding, we need your help. That's normally what's done in cases like these. We need a detainer, Judge. We need your help, Judge. We want your help. That we go to another colleague and say, we want your help. But I'm going to need to have a hearing to fetter out what all happened because this is just conclusive.
Your Honor, may I give you the background of how we wound up in front of Judge Hathaway?
I'd like to know.
From the beginning of this investigation, which is now years old, we've been going to the same...
What? 9 years old.
Is now years old.
Okay.
I apologize.
Well, it's not that much because I believe the anniversary of Ms. Jane Bashara's murder death is tomorrow. Is that correct?
Yes.
Yes or no?
Yes, it is.
So it's not years. We're talking about 2 years, okay?
2 years.
Okay, 2 years. So, okay.
So from the beginning of the investigation, the same judge has been gone to for search warrants to maintain...
That's not true. You say that Judge Michael Hathaway, since the beginning of this hearing, since the beginning of this investigation, is the person that you've been going to? Is that what you're saying?
My understanding, no. That is not what I'm saying.
Well, then make your understanding clear.
From the beginning of the investigation, it has been the practice of, as far as I know, the investigators to go to the same judge. In this case,
Judge Kenny.
In this case, Judge Kenny had to recuse himself, so he went to his alternate, which is Judge Michael Hathaway. And that's how we wound up there. It was trying to follow the same process.
Wait a minute. So Judge Kenny's alternate is Michael Hathaway.
That's what the investigator informed me.
Okay. All right. So I'm just curious. When Miss Lindsay, I'm gonna hit down, and I'm gonna let you speak. Okay. We got till 4:30 today to feather this out the best we can. So you go to this judge after the case is in front of me. I mean, I just want to know, because that's a different practice. Are you aware of that practice, Mr. Shire?
Not in state or federal court.
And, Your Honor, if that was a miscalculation, that was a miscalculation. But the fact is...
Miscalculation? Be quiet in the back, sir. Okay? We don't need your input. A miscalculation.
We have, for the record, I believe that's Mr. Falcinelli, a witness in this case.
Mr. Falcinelli, step outside, because you may need to testify ultimately.
He's not a witness in these proceedings, but he can step
He
up.
may be, because I think that I'm going to end up having to conduct my own evidentiary hearing. Step on the south side. Okay, now I'm listening to you. The miscalculation, that's where you left off at.
Thank you, Your Honor. If that was a misstep to go to Judge Hathaway, then it was made. But we're here because the search warrant was signed and it was executed. And we're talking about the property that was seized pursuant to that search warrant. And so I would like to focus on that property, if Your Honor is willing to go there.
Well, I am, but I'm going to let Ms. Lindsay chime in.
Well,
or make her position known. I'm listening as far as, wait a minute, you're not Ms. Lindsay, sit down. Go ahead.
the only thing I would like to indicate is that from the very beginning, even before a case was instituted, when you're talking about investigative subpoenas, we took our investigative subpoenas starting with Judge Kenny. And basically every investigation...
Who is the presiding judge, just for the record?
Right.
A criminal division.
And we have tried to keep consistency with the person who reviewed it, because when you take it to somebody else, you have to do so much backtracking and explaining that if a person has viewed the thing from day one, they can follow it.
And Ms. Lindsay,
can I just, Judge, please?
But Ms. Lindsay, when we not talk about a person, talking about judges.
No,
Okay? We're not talking about a person. We're talking about judges. But go ahead, ma'am.
I understand, Judge. And as it relates, I believe you have been given a copy of the search warrant at this point.
I got it yesterday.
And I warrant is in excess of, what, 20 pages or something like that?
Yes.
Okay. And as it relates to why we kept going to the same person is because the case is complicated, convoluted, and...
Oh, I'm in error. I'm in error. The search warrant is 10 pages.
Oh, 10 pages.
Okay.
So,
Okay, very good.
Okay. And so that's why it was taken to Judge Kenny, because he had the working knowledge, and when you go to him, it's a quicker process because you don't have to backtrack and bring other documents in for somebody to read.
But that's not procedurally correct.
Well,
and I understand that we're all looking for efficiency and we want to do things fast, but some things have to be done proper and in order. Yeah?
okay.
All right?
Okay.
And that's what my concern is that we're not dealing with a lay individual. We're dealing with judges. So my concern is what was so difficult to bring this search warrant to this court to say, Judge Vonda Evans, what is your take on this search warrant, and would you be willing to sign it? Because you now are assigned to this case. Now, what I keep hearing, it is convenient, complex, complicated. Now, as I've indicated before, it is my belief that this is a murder case and which is getting a lot of media notoriety. But the fact of complex, complicated does not exempt Madam Prosecutor, Mr. Prosecutor, or Mr. Defense, or even Madam Judge from following the law.
Can I just finish without you interrupting me, Judge?
Okay, I'm listening.
The chief judge of the court.
The presiding,
Yes.
not the chief.
The presiding judge of the criminal division, he did not indicate that we should take it anywhere else. Once he determined that he could not do it, he did not say take it to Judge Michael Hathaway,
But
and
let me
we
ask you a
followed his
question.
direction.
Madam Lindsay, Miss Prosecutor, why was okay, you're saying because he had been presiding over it previously, is that correct?
Correct.
And so it was whose decision in the prosecutor's office for let me ask a question. That they had to prepare a search warrant. You all are busy. If they said, well, Miss Lindsay, oh, okay, I'll leave a voicemail. I'll wait till she calls me back. Because the substance of the call is in excess of 5 months.
I think I think although Mr. Hindenlang might have only put it in his brief something in March, I think there was something much more recent than that. I think the
last one was October 6th, according to his motion.
yes.
So this was not something that there was a fear could be ultimately destroyed. And why was it that this decision had to be made within the time frame that he was downstairs when we talk about Grosse Pointe Police or Wayne County Prosecutor Investigators?
Well, and the other thing is, one of the things, we weren't sure where the writings were. So we were trying to keep listening to get a pinpoint location.
Okay, but...
Can I finish? Judge, you're interrupting me. I will
Okay.
The thing is, when you hear something, you still don't know the exact location. So we're trying to listen to find out, follow-up information about the exact location of where the writings are. So even though it's said on October 6th, we don't know where the writings are. We're still trying to gather more information so we can pinpoint, because he's talking about transferring the writings from Mr. Valente to Mr. Falcinelli. So we don't know, in the scheme of things, when the writings have been transferred. So then you have to listen to his calls to Mr. Falcinelli to find out whether Mr. Falcinelli indicates, hey, he transferred the writings to me. It's not just a simple matter you can say on October 6th he made this call. You still have to find out where you're going to execute a search warrant, if you're going to execute a search warrant.
But let me ask this question. why wasn't a subpoena given to Mr. Valenti as a courtesy, as a lawyer, knowing that there may have been a chance that the search warrant indicates in his home and his office, for him to provide you with the information? Because it does not appear from what is stated in defense's motion or the prosecution response that there was any concern of immediate destruction. So this was not a situation where, you know, there was a smoking gun. There was a situation. I'm not dealing with that. I'm just dealing with what's at Dean Valenti's. I'm not talking about the lawyer, Mr. Grimm, or however that reason came in. I'm not there yet. But my point is that why wasn't this affiant, when he was unable to secure you, Mr. Moran, or Mr. Henderling, why wouldn't he say, well, you know what, this is ongoing. You know, we can wait a day or two till they call us back to tell us where we should go.
Ma'am, Judge, Your Honor, the subpoena was, they went there with a subpoena and the search warrant on the same day. So it's not like they didn't give him the option of the subpoena.
Okay,
it is my understanding, Judge, you asked me a question, and then before I give you the answer, you interrupt me, Judge.
I'm sorry.
Okay. So when they went with the subpoena, they had a search warrant in their back pocket.
Signed by a judge that's not connected to this case at all.
Yeah, that's true.
Right.
Okay. And when Mr. Valenti, is my understanding from what the officer said, Mr. Valenti said he would not honor the search warrant. Then they did honor the subpoena. Then they did the search warrant. Now the reason why it had to be executed at that point in time, because if they had left the home, they can't surround his home forever. If they had left the home after he refused to comply with the subpoena, the writings could very easily have been destroyed. So you say there was no rush at that point. Yes, there was, because once we alert him that we're looking for these writings, and we leave, there is no guarantee that those writings would stay there, or that he would not transfer them or move them.
But my concern, procedurally, okay, and I am tired of hearing the word complex and complicated.
I didn't say that in my last exchange.
Okay, but I'm tired, or this is so unique, that we don't have to follow the rules as not the law, but the rules that we do with any other case. And go to other judges when judges are assigned to oversee a matter. Oh, well, I can see if I wasn't here. I was here that day. There was not an availability issue. And moreover, the emergency judge that day was Judge Shalinsky. It wasn't even Judge Michael Hathaway. Because if a defense attorney were to do something like that, the first thing they say is form shopping. We're trying to find a judge that's going to go along with what we want. And that's why we went. It has that appearance. And excuse me, I'm not done. And that's my concern. And I understand what you did before you got to the trial judge. You here now. And I'm not going to go further with this. However, I'm going to indicate to the prosecution and defense that if there are any more subpoenas that are going out or search warrants, I must be notified. I am responsible for this case, and unless I decide that someone else, or I delegate that responsibility, or the Court of Appeals feels that I'm not able to do my job, then it goes somewhere else. But the day of having you go around this court to decide who you want to sign a search warrant is over.
Judge.
It is over. No, Miss Lindsay.
No, Judge.
I've heard enough, and I don't want to hear any more.
Judge, you don't have to yell.
I'm sorry.
You don't have to
I
yell
don't
at me.
want to hear any more.
To you in a respectful
No, and this is why. Let me
just-
explain this to you. Ma'am, please. And I'm putting this on the record. I am tired of having people, prosecutors, or defense attorneys come into court, and if you don't like what I do, there are two levels of review. the Judicial Tenure Commission, and a Court of Appeals.
Judge,
Wait,
that was...
I'm not done.
Yes, ma'am.
I'm not done, and when I'm done, I'm gonna let you make a record. But that's over. And I don't care how complex and complicated, I am the presiding judge over this trial, over this matter. And anything else will come through me. I would never ask my courtroom prosecutor, who is a member of the Wayne County Prosecutor's Office, to stand in on any motion that had to do with the Bashara case. Why? She's a lawyer. She works for the prosecutor's office, because it is the practice of this court that the attorneys that are assigned to this matter are the ones that should be placed on this record. And if Miss Lindsay was in another court, Mr. Henderling was downstairs in another court, I didn't proceed without him, because it's not proper. Well, I'm sorry, Judge, it may take Miss Lindsay in Washington, D.C. I gotta wait. That's how things are done. And that's my expectation. Now, what I want to do at this point is, because the court was very taken aback by what occurred, the going to Michael Hathaway, to allowing Gene Stempien, who I'm now hearing wasn't even one of the three that was agreed upon, that other people are making decisions about my case. Because, see, ultimately, if there is a review of this case, I am responsible. And I'm not going to be responsible for anything any other judge has done without my knowledge and without my consent. Nor would I expect you all to do that. Now, what I'm going to do is that obviously I've reviewed the law. There is an agreement between the parties that the search warrant was proper. So there's no review of that, okay? But what I need to do is that there was a determination made by Judge Stempien as to what is privileged and what is not. I am going to review those documents, and I am going to make a determination. The law that you quoted in this response was that you relied upon was the federal rules that allow for this type of this type of review, and was indicated, although not binding on this court, there is authority pursuant to the federal rules for in error. The case that the petitioner relies upon is a case that relates to illegally seized forfeiture property. The court uses the federal rules of criminal procedure, which do not apply here, to return illegally seized property, which the material at issue is admittedly not. In short, the petitioner provides no authority that supersedes the plain language of the statute. Okay, so just as you recommended that the court can use federal rules of criminal procedure, you can recommend that I review the master's review, but I'm not depending on Judge Stempien's review, although I have high respect and regard for her as a jurist, to determine what matters will be admissible in this trial with Mr. Bashara before this court. So what I plan to do is this. I'm going to do two things. I want to conduct an evidentiary hearing in this matter, okay? And then I want the copy of the review or the finding of Judge Stempien that was shared with the parties and Michael Hathaway, Judge Michael Hathaway. I would like to review it. And I want those items made available to me ultimately, so that I can do an in-camera inspection to determine whether or not her findings, which are persuasive but are not binding, will be admitted in this particular matter. So now that's what I'm going to do. But Madam
Okay.
Prosecutor, this is your opportunity. I'm listening.
This is what I want to say, Judge, so it's clear. It is not the way you stated your reasoning that it made it seem like you had ruled against the people in this particular case and we went elsewhere. I just wanted to make it clear you did.
Well, clearly that, and if that was the, if you took that, I intimated that, that's incorrect.
Okay.
What I'm saying about form shopping
No, I understand, but
is finding someone that you may say, you know what, she may not grant this, but maybe another judge will.
no, I understand, but just so it is clear,
That's
it is,
not what
it is
occurred.
not a situation where we came to this court on this case and you ruled against us and we went around you. That did not happen. And I just want to make it clear so the impression is that we did not go around you because we thought you would rule against
No, you
us.
never came to me.
Right, that is correct.
Oh, okay.
That the affiant never
Came to
you.
you.
That is
Right.
correct. The court knows, and I have had a long history of this court, with this court. I have never disrespected this court
Never.
in any shape, way, form, or fashion.
But let me just indicate this, Miss Lindsay. This is not your motion.
No, I understand that.
Excuse me, and I have the utmost respect for you. This is Mr. Hinderling's motion. And it's a surprise to the court, mainly because, honestly, I am really concerned, and my concern really is this. At some point, we got to try this case. What occurred with why Mr. Bashir is in custody now, it came in part because of conversations that were made on the phone. It's ironic to the court that he would be even making anything inculpatory. But what it does, it makes situations appear to be different from what they actually are. And what I'm saying to you is that we need to proceed at some point with this, because now we've got this other hearing that really didn't have anything to do with this case, that if a higher court has an opportunity to review. It's almost as if because of the way that things are done, we're building in things in this record that shouldn't really even be here, based upon reviews of things that may not even be true. That's my concern. And I don't want to continue to go forward in this matter. At some point in time, I understand it, and I'm only assessing this based on the limited information I have. But what is so difficult for the court to understand, based on my understanding, there were only 3 people allegedly in this garage. We got 178 witnesses. But I don't know, because I'm not going to say, because that's your job. But what I am concerned about is that there's enough that we have to deal with, that we should not continue to have to deal with ancillary issues in this matter. And so what we're going to do in order for this record to be complete, because it does need to be complete, we know off right now that there is, and the court is going to so find, and we can even draft a document, but it's based on email, that there is no objection to, or there's no challenge to the legality of the search warrant. Is that my understanding?
We haven't even seen the search warrant, but for purposes of getting our property back, we weren't opposing it. How can we agree that it was a valid search warrant if we weren't able ever to see the affidavit? All we did was we conceded for purposes of getting our property back that we weren't going to challenge it at the time. Whether Mr. Bashara wants to raise issues when he gets a copy of the affidavit, and whether we want to...
Well, according to your email, you didn't raise that issue of the legality of
At
it,
that
and
time.
that's
Right.
at the time.
Yeah.
So the court is going to solve. I'm not even going there.
Okay.
What I'm concerned about, and I've gone over, and now I somewhat do understand that there was a recusal by the chief judge because there was, and I'd like to know that information, why there was a recusal, so that we can make that part of the record, but that ultimately was sent to Michael Hathaway. And I ultimately just want to know what the affiant did procedurally and what the procedure was in obtaining this information. And then once secured, the court wants to review the finding by Judge Stempian, and then the court wants to do an in-camera review. But I'm not here to challenge the legality of that document. I would like to know procedurally what occurred, and I think that we can do that basically with the officer in charge of the affiant as far as whatever occurred. I'm not saying that Mr. Shard is in a position to, waive anything, but as for the purpose of the return of his property, then the court is going to so make a finding that based on his email, that there is an agreement at this point that going forward as to the return, that there is nothing wrong with the search warrant. Is that my understanding?
Yes.
Okay, Very, is that my understanding?
Thank
And
you.
if there is a issue that comes before this court, okay, regarding that, that the proper form, once we supplement this record, would be to send it back to the person that actually did the search warrant. I would not, because I cannot, because as a judge, I sit with equal authority with Michael Hathaway. So I'm not in a position to do anything with that. But what I then want to do is find out procedurally what was done with the affiant, the cause, and the procedure, that what was secured. I do have a return. Did you see the return?
No.
You didn't preside the return to him?
Your Honor, the affidavit and the return were suppressed by order of the court. The return was supplied to Mr. Shard via email.
When?
Did you receive
Never got a
this?
copy of the return.
Okay, please. May I? I have a copy.
Of the box 2, the log and the inventory of box 2.
Okay.
And
I
it
do
was supplied by
believe at
email.
this
I'll give it to him
point in
again.
time, that this, and you've indicated email, you did email him this to him, right? Excuse me?
The inventory, yes. And I can email it to him again.
Okay.
Along with the email that he sent me.
Well,
Absolutely.
that's fine.
Sure.
Okay, so this is what I want to do. We're going to have to, I want to gather all that, and it's my understanding that Judge Stempian did make a finding?
No, she has conducted the review and completed the review, but has not issued the report back to Judge Hathaway, to my knowledge.
Okay. Well, you make sure that I get a copy of that.
Of course.
Okay?
And, Your Honor, to be perfectly clear, the files are in our office and remain open. If Mr. Shard and Mr. Valenti want to identify the files that they need to conduct Mr. Valenti's practice, they can. And we will either get him the originals if they aren't needed for evidentiary reasons, or we'll make him copies.
Judge, we want box 2. We want that second box that we conceded. If they want some materials from that box of his files, they can make copies, and they're playing this game with us about meeting with them, and we can identify the files that we want, then they'll make copies for us. They've had that box number 2, for 2 months. And in fact, they've inventoried it, they can make copies of what they want, and they can return that box to us. That's why we're here today. From day one, they've been playing the same game.
And,
Oh,
Your
I'm
Honor,
not gonna say that they're playing no game, that that's the procedure they wanna follow, but now we have a different procedure that's gonna be in place.
And,
And I'm just gonna say for the record too, Mr. Shire, you talking about a game being played. I have, and I use that term because you did, but I have emails that have been provided from this court from December 7th to January 15, 2014, and there was not one time that you came before this court and said, hey, Judge, we need your help.
I did.
Show me an email.
No, because I finally emailed you because we were playing, because of what they were playing. I thought,
Well,
I better get Judge Evans involved in this because she was a trial judge and I had no idea why we were in front of Judge Hathaway. I still don't know why we were in front of Judge Hathaway, other than the fact, Judge, that this isn't just a regular search warrant. This was a search warrant of an attorney's practice, of his files. And if you don't think that the investigators talk to the prosecutors before they execute a search warrant on an attorney's law office, Then we're both at Bridgegate in New Jersey right
Well,
now.
I'm not gonna rule on that, and all I wanna know is procedurally, is that, why they went there. If they said that's what they, normal course, and that was his alternate, then I just wanna understand, procedurally went there, what they took, so that I can take a look at the documents and do an in-camera inspection and make a determination after I review Judge Stimpion's report. So, excuse me, what are we talking about? When is the report gonna be ready?
I don't know. I don't know. Judge Stempian hasn't given me or conveyed any type of timeline.
Okay, because
However,
this is what I'm concerned about. I received this from you, Mr. Hendeling, as of Tuesday, January 14th, 2014 at 1:34, Mark Hendeling, from Gene Stempion. I have completed the review as of Wednesday. I have talked to Judge Hathaway, Michael. I spoke to Judge Vonda Evans and informed her of my role in this part of the litigation, portion of litigation. I did not do that in writing, but can do that so everyone is comfortable. At no time did anyone interfere with my review. I was alone in the room and never approached until concluded. If anyone has any questions, please set up a conference call ASAP Gene Stempion. For the record, when this is referred that she informed me, okay, it was at a dinner party hosted at a colleague's home during a holiday. That's not what I consider informing somebody of what their role was. That's not tantamount. So this is in error. So I'm making that for the record. But at this point in time, if she's saying that she completed a review as of Wednesday, that would have been January 15th. I want that report from her no later than the 29th, and I want that report sent only to me. It can be CC'd to Judge Michael Hathaway, but at this point, I am intervening in this matter. You can give her my information, and anything I need to discuss with her, she can send it to me, and I'll provide you with the email off the record. I need to have that forthwith. We then, after I review this, after you have an opportunity, because I understand that there are numerous people, I'm in trial, you're in trial, the likelihood that we're going to be able to get this matter done when I want to get it done doesn't look like it, but albeit, the issue that we are all concerned about is the fairness of the trial for everybody involved. Mr. Bashara,
The only issue we have is box number 2.
Okay, well, excuse me, all right. So, if she can get me that by the 29th, would it be unreasonable to think that we could come back in here maybe February 18th? Could you check your trial schedule?
In the afternoon.
Yeah, could we do an afternoon?
The 18th should be good.
You sure?
Yes.
All I want are the affiant, not to basically, just to indicate to me procedurally what was done. Because I'm not ruling on the legality and admissibility. I'm just wanting to know procedurally what was done, and then when they secured the time, what they got, and then we'll set something up from there. But I need to have that, I don't even know really if I do want to have her findings. Or should I just do it
You
on
have
camera?
to, based upon procedure, when documents are seized from a law office that involve work product or privilege, if you're supposed to have a master, but that was because Judge Hathaway was the one who
Well,
signed it.
irrespective, I believe that based upon what I believe the evidence will show, and that is that you've indicated as an officer of court, Judge Kenny couldn't do it, he sent it to his alternate, that he made a determination based on that. But I'm jumping the gun because I believe the representative will testify to that ultimately. But my issue then becomes one of whether or not my decision on what was privileged or not privileged, or my finding, would be any way influenced by her finding, or should I make one independently, or do you all have a
No,
position?
I think it's...
Well, no, Ms. Lindsay, I don't want to interrupt you. I want you to say something.
As I indicated to the court, that this portion of the litigation is being handled by Mr. Hendeling in terms of the decisions to make. He's done all the research of law on this area. That's why I would defer to him as to what he feels, because he did all the legal research as it related to this issue. So,
Well, you know what, maybe it might be incumbent upon me, because I'm gonna tell you, I have not had this, problem before, or it never occurred
Well,
before.
they don't raid attorneys' offices every day, Judge.
Your Honor.
Okay, well, they don't do it with cases in before me, okay?
The
So-
files are open for your review. If you
My
would find
point to
Judge
you
Stempien's
is-
report helpful, then I think that you can look at it.
No, but what I'm concerned about is even before we even have anything from her, let's do a little, maybe a brief on what procedurally, legally is a procedure. I don't want to make a decision that could somehow, or be influenced by a report that somehow could be later challenging my decision. That's what I'm concerned about.
Judge, the proper procedure is for the magistrate, for the master to make a recommendation to you. It's only a recommendation, and then you can do a de novo hearing. And that's the
Okay.
way it's supposed to be.
I believe that's correct, and that's what we agreed to in front of Judge Hathaway.
Oh, okay, well, that is suspended. That'll be before me.
Okay,
Understood.
good.
Okay,
Understood.
very good. So what we need to do is, so are we still good with that date?
Yes, the 18th, and I'll check with the affiant to make sure he's available.
Okay, very good. And you'll correspond with
Of course.
us through email?
Yes.
Please provide that return.
Absolutely.
And the email that it was attached to.
It will all go to Mr. Shark again.
Okay, thank you, Judge. I have to catch a train to Toronto.
Mr. Sharp,
Your Honor, before we close the record, there is one other clarification. The authority that you mentioned, the federal authority, was in the petitioner's brief, Mr. Sharp, at this time. The authority upon which I'm relying is MCL 780-655, Section 2, the statute.
Right. Okay, very good. That comes back. Good luck. Okay, very good. Okay. I'm not done. You may be excused.
Your Honor, may I be excused to go back to my trial?
Are you prepared to go forward with the next phase of this litigation?
yes, Your Honor.
You sure?
Yes.
All right, very good. You may.
Thank you, Your Honor.
Okay, very good. I'll get it to you. You ready? Back on the record. Come on up, Mr. Bashara. Appearances for the record.
Lisa Lindsay on behalf of the people of the state of Michigan.
Mark Persida on behalf of Mr. Bashara.
Nancy Shelter, on behalf of Mr. Bashara.
Okay, Mr. Bashara, since we were last here, has Mr. Rosita been to visit you?
Yes, ma'am.
And have you been able to go over the substance of the material that he provided to you?
He did provide me material, Your Honor. Part of my problem is on Monday I had eye surgery, and as a result I have not been able to read for the past 5 days. But he has gone over things. He provided me with additional material. He said more is coming, and so we're moving forward with that.
Okay, Mr. Persida, I thought that you were going to give me an order for an investment.
Your Honor, I have that today, and I also have another order. I spoke with Ms. Lindsay. She has no objection to the order for the investigator. We have also prepared, Judge, pursuant to what occurred last, an order granting defendant access to pens, writing pads, and a magnifying device. I have that. Ms. Lindsay did not agree to that, but I brought it here, and if the court can offer us any guidance from here, or if you have an objection to signing this order, Judge, I'm just looking for some guidance so that we can get what we need to get moving.
I have no objection to magnifying glass or whatever the magnifying device. I have no objection to writing pads, but it's my understanding from speaking to the jail, they do not allow ink pens because they can be fashioned into weapons. They do give them writing utensils, they give them pencils. So that's my position. I have no problem with him getting magnifying glass. I have no problem
He's
with
by
writing.
himself.
That might be he might be by himself,
That's what they provide you.
Yes, ma'am.
That's inadequate.
but they provide that to every
That's
defendant
inadequate.
in the
That's
jail.
inadequate. That's inadequate. That little pencil,
Right.
don't even have an eraser on it.
No, ma'am.
That's inadequate. That's inadequate. So the court is gonna require that he get some other type of writing utensil. Honestly, let me ask you, you know what? I am still concerned going forward with whether or not the court should appoint new counsel.
To what, I'm sorry?
Appoint new counsel. I'm not persuaded, I'm not sure, and I'm gonna take it under advisement. I don't know whether or not going forward if I should leave the defender's office on this matter.
May I address that, Your Honor?
No,
Okay.
Maybe I am under a misunderstanding, but I understood when we had our conference call last
Well,
week, all of us, we had a conference call together, and at that point,
I'm not sure. I'm not sure. And what really made me somewhat reluctant, you know, and for the record, there was a conference call that was held last week. After I got all of this information about what occurred with the discovery at the home of Dean Valenti. The court, even though that they were not an active party to this matter, I'm just concerned that maybe at this point, the representation here or the lack of resources is going to not provide the defendant with the type of representation and counsel that he deserves. And I'm going to make a decision.
can I just interject, Judge?
Yes.
As it doesn't really matter who was on the case, whether it was defender's office or anybody else, a search warrant if it had been issued, was sealed, they weren't going to get access to it until after the judge unsealed it anyway. So no matter who was on the case, they were not going to get access to it till the court unseals it.
Well,
And the
I
court will
understand
unseal
that.
it.
Judge, may I be heard?
I'm listening.
I was in fact at the meeting with Judge Hathaway. I was told by Judge Hathaway we did not have standing at that point, which I found peculiar because it is the defendant's privilege that we're talking about here. I was told that we do not have privilege, that the prosecutor could leave both the affidavit and search warrant as well as the return, that it was suppressed, that Judge Hathaway signed that order, and we were denied access to that. I had already talked to Michelle about whatever hearing is held, Judge. I think it would be expedient for all of us to allow us to join that hearing and also contest, if necessary, the constitutionality of it from a probable cause standpoint. But Judge, we're caught because we don't know and have been told by Judge Hathaway we are not entitled to know what was seized, what the probable cause was to seize those documents, and that hamstrings
Well,
us.
any issues regarding the search warrants,
Can I
if
just
Judge
jump in?
Hathaway signed it, then he's gonna be responsible for conducting a hearing for it too.
As it relates to that, all the search warrants in this case from day one were sealed, and when they were unsealed, they were turned over to defense counsel. They have them now, and that does not preclude them from bringing motions to suppress at any point in time. So once again, even though this particular search warrant and affidavit was sealed, that's the course it has been on every search warrant in this case. When they were unsealed, they were turned over as part of discovery, which he has the majority of them now, and he is free at any motion hearing to challenge the legality of any search warrant that was brought. So I'm saying that to just say that this one issue does not cloud everything or affect everything in the case, because even though the search warrant goes to another judge, when it comes trial time, they can still move to suppress the evidence. So
Oh, clearly.
But,
yeah.
but in the meantime, we don't know what Sarah Judge, I can't file a
But
motion.
see, and this is the thing, I'm concerned about the resources that the defender's office has and that they're willing to commit to this matter. And I'm not persuaded that although we have been using the term very loosely, or I have, complex, complicated, there is a lot of material. A lot. Ultimately, the issue that will go before the court, the trier fact and judges of the fact will be obviously the premeditation. But the discovery And I don't know if the defendant's office is willing to commit those resources, i.e. to hire extra staff to be able to assist in cataloging different information. And if I can be in a position to give Mr. Bashara a new counsel that could assure us that they would have the resources to commit to this case so that we could be up to par with the prosecutor, I think that that's something that I need to ponder, and I have been. And I believe that I'm going to make a decision when we come back on February 18th as to what I'm going to do.
Judge, can we just have at this point Mr. Bashara waiving on the record any claim as to a speedy trial, because, and this is my fear, that if the court does appoint new counsel, everybody when they first get into it might underestimate the amount of time it needs. When you appoint new counsel, say you have to be ready,
Well, let me ask this to you, Mr. Bashara. Do you understand that you have a right to have a speedy trial?
Yes, I do.
And do you understand that if the court were to appoint counsel to you, that could prolong this trial?
I would hope it would, so they would have the opportunity to go through the discovery and properly defend
So
it.
it's my understanding that's what you're concerned about. You're concerned about the fairness and you're concerned about you being adequately informed of the information.
I'm concerned about the whole process, Your Honor, that I get a fair trial, that the resources
Are
that
committed.
that Mr. Presida and Michelle have available to them be allowed to be given to them, because the
But see,
prosecution...
here's the problem, and this is the issue. Because they are from another organization, I cannot overrule their boss. I can't say, well, we'll give you a budget, or the court will acknowledge a budget to have support people to come in, etc. But if I were able to do that, I could do that with private defense attorney. But the issue is that I have to conduct this matter in 180 days. And what we can just go forward, or we can try to amend this, to have some kind of a waiver ultimately to do a thorough job, but it may mean waiving that 180 days. Do you understand?
I do understand that.
And what's your position? Do you want to wait or what?
No, Your Honor, my position is that I was happy with all three of the attorneys.
Right, I know.
Mr. Cooper, Ms. Presida, and Ms. Shell. I am disappointed that Mr. Cooper is off the case, and I think it has to do supposedly with...
I don't want to know.
Okay, I don't know either. All I know is I'm also very happy with Mr. Presida and Ms.
He's
Shell.
a great lawyer.
Yes.
It has no reflection on that.
No.
It is the resources that their organization is willing to commit.
Judge, may I interject here?
That's what I'm concerned about.
Two things. We discussed at the conference that we had last week.
Right, on the phone.
I've already contacted Mr. Krishunas, and he's investigating it. Those are law students. We have also, I talked to Mr. Johnson, we have also reached out to some of our benefactor firms, requesting that they perhaps, if possible, provide us with a first-year associate that may be willing to get from the litigation section, that may be willing to get involved on a team. We're making efforts, Judge. I feel our office does a very good job. I feel we can provide Mr. Bashara with an excellent defense. But just so everybody's on the same page, Judge, we're not just sitting back. We're taking steps to make sure that he gets not an adequate defense, Judge, but a good defense.
Mr. Presida, I know your reputation and it's stellar,
Thank you, Judge.
and as well as Michelle. I know it. But the problem becomes one is that, as my father used to say, sometimes your best ain't good enough. And this is what I mean by that. The resources that will be able to be committed to this particular trial. We know that, we were behind on getting him the preliminary exam transcripts, but now we're getting up to par with that. There has to be someone that is committed to cataloging this information so that the two of you can adequately review. Despite your experience, I have to take into consideration the fact of that there is numerous discovery matters. And my issue then becomes, is there the support from your organization that will allow you to do the job that you are accustomed to do and that you did when you were in private practice? That's my concern.
I think so, Judge. I mean, ultimately, and may I note,
Because, wait a minute, one second. Miss Lindsay, how many pieces of discovery we actually talking about? In excess of 10,000?
Well, it depends on how you, there are some things that are computer files, so you can't really quantify computer files. You just have to go through and do the searches on the computer. There are numerous witness statements, but the witness statements are very easy reads. There are approximately 300 witness statements, but not all of them are substantive witness statements. You have to take witness statements from people who give tips who might turn out not to know something. So there are a lot of witness statements, but as it relates to the core of the case, we are limiting the core of the case. We met with counsel and we knocked off some witnesses, and so there's a process of whittling down. You start with when you're doing an emancipation.
Counsel, that's not my question. My question is approximately how many pages we do? In excess of 10,000?
Yes.
It's
Yes.
clearly in excess.
Yes, because I have 1,000-page binders and I have at least 10,000-page binders full.
I know, okay.
So-
And I don't know that, I know my concern is, and it's no reflection on the organization, it's a funding issue. It is a funding issue, and if I have an opportunity to have private attorneys to come on that I can give a budget to, that will enable them to do more investigation, properly putting things together, meeting with Mr. Bashara, I gotta think about that. And it's no reflection on the defender's office. They're wonderful. They do wonderful job. I wish I could give them money to do this.
We'll
I wish
take
I could
it.
give you money to do this. And I think you take it. But I have been given authority to make that consideration. You indicated that you may want someone. I'm going to take that under advisement because I have been given the authority from this court to extend the same rate that is extended to the federal defender's office, which is $125 an hour, to have 2 attorneys to be placed on this case for you, which means that this court could commit in excess of $200,000, maybe around that amount. And I think that would adequately. And I just have to make that decision. Do you understand that, Mr. Bashir?
I'm sorry,
You
okay.
understand that?
I do understand that.
But I don't want to usurp your decision. If you want to roll with them, you can do that.
Judge, can
I mean, I asked you.
No, I don't want to weigh in on whether his decision, there's one more factor I need to put on the record.
But I'm not ready for that. Okay, what, Mr. Bashir?
Your Honor, while I appreciate you wanting to afford me the best possible defense, and certainly I want that, I am very confident that Mr. Procida and Ms. Schell can proceed. However, we have talked to a third attorney who is,
Who?
he asked that I not disclose his name publicly, but because he has not decided whether he'll come on board.
But there are some limitations.
Right.
And the limitations that I'm dealing with is that that person has to be on the assigned counsel list in Wayne County.
Right.
And if they're not, they cannot come in.
certainly.
Well, Your Honor, like I say, I hope that Mr. Procida and the Office of the Defenders uses every resource that the court can
Well, look.
provide to
Look,
aid in
listen
their
to me.
defense.
You had your opportunity, and if you don't want to exercise it, we can go farther. Maybe I can even ask whether or not some other attorneys in addition to these be appointed. There has to be more. And there has to be more resources. And I've got to make that decision, okay, ultimately. But what did you want to say?
Just if someone new comes in to replace the defender's office, just as a modest estimate, Judge, I believe it's going to take them 6 to 9 months to get up to speed.
I disagree.
Well, I understand you disagree, but you have also not lived with the case the way I have lived with the case. And defense counsel, it took them, in order to be able to get up to speed to do the exam, at least 3 months. So you're talking about 3 months in addition to receiving the initial package. So I know the court doesn't disagree, the court disagrees, but the court is somewhat, can I finish, Judge, because you
Go
start
ahead.
shaking your head and you start, you know. The court might disagree, but the court has not seen what they have seen. And when I indicated it would take 6 to 9 months to get up to speed, Mr. Procida started shaking his head because he knows the court is somewhat in the dark as to what we have. We know what the stuff is. The court doesn't. So when the court says, I disagree that it's going to take somebody to 6 to 9 months to get up to speed, your disagreement is not based on what we know.
But, and you know what, I can appreciate that. But at the end of the day, it took several months to even charge Mr. Bashara. This is not a rush. We want to do a thorough job, okay? And that's what I'm doing. I'm going to come back February 18th. I'm going to ultimately make a decision if we can expand this team, because you've indicated that you're happy with them. I just believe that there could be more resources expended, and there's no way that they can be expended in the fashion that normally would be done because they're part of an organization. So I need to go back to find out what we can do. In the meantime, I'd like to know, you know, about this attorney, whatever.
Absolutely.
Okay, and in the meantime, I need to sign this order for a discovery. For an investigator, I'm granting that obviously at public expense. And by the 18th, I want to know where you're going with having more people, the assistants, you know, the clerical individuals or the people that can catalog this. I want to know where we're going with that, okay?
Certainly, Judge.
And you've indicated that some of the benefactors have indicated that they may give a third year.
We-
And that would relieve the court completely from being able to have to subsidize Mr. Bashira's defense, okay?
And Judge, they do that in the interest of providing pro bono hours. So we're hoping to get, if possible, one of their first-year associates.
But you believe that you'll be able to let me know by February 18th?
Oh, absolutely. We'll know that within the next week or two, I would
Very
assume.
good. All right, very good. I'll see everybody on February 18th. Any other issues?
Nothing I can help, Judge.
Thank you so much. Yes, Mr.
I
Bashir.
want to
Good.
thank you very much for recognizing the second anniversary of my wife's passing. And I just want to say that, please, everyone, don't forget
Thank you,
Susan
sir.
Murphy.
Make that order. I'm not going to allow him at least pencils with a eraser or something like that, modified. That concludes this matter. Thank you. The court is on a 10-minute recess.
That's fine.